On me that there shouldn't be that lawyers tend to take over these discussions with a lot of conversations about what happens in court and the court section and verse, and that I should be more nuanced in my presentation. Unfortunately, I'm going to fall back on what I know best, and that is the law. So there has been much conversation about how the law has changed in after 2013. Has it really changed? As a practitioner of the law and as someone who goes to court every day, I really don't see any change, because the language is the same, the prejudices are the same, and the judgments are the same. If anything, the new law and the fact that you have to adhere to certain new standards has only made courts and judges look at ways and means of bypassing those impediments, as they call it. It is still very difficult to prosecute an offense of rape in a courtroom. It is still extremely difficult for a woman who has been sexually assaulted to come to court and to testify. It is still the same kind of cross-examination. So what really has changed? And it is still the same language in judgments. So this, the 2013 moment, whatever it achieved or didn't achieve, what I can say authoritatively is that nothing magical has happened on the ground. And things are pretty much as depressing as they used to be. The only thing that has increased with every passing month is that 10 years becomes 20 years, 20 years becomes for the remainder of your life, and the remainder of your life then becomes death penalty. Which is true not just of offenses like rape, but it's true across the board. I mean, if you look at any offense, under any provision, under any statute, there's always a minimum sentence, and there are very, very high punishments. So I don't know where this is all taking us, and it really, for me, it's sometimes irritating that women, that feminists often say, you know, there is no, there's no discretion given to the judge for purposes of lowering the sentence. That's true, but there's no discretion anyway, and across the board, in all manner of offenses, you see very, very high sentences, and you see virtually no discretion. And even if that discretion is available, judges rarely use it. And if they use it in a way that will horrify any practitioner of the law. One of the things that I noticed in this book, and Madhu has written about it, where she talks about virginity and the institution of marriage playing such an important role when it comes to determining the offense of rape in a courtroom. In the judicial mind, there seems to be a connection between an unmarried woman's sexual activity and her ability to consent or refuse to consent to sex with men. The assumption converts rape trials into roving inquiries in the victim's sexual past, sourcing whatever information that fuels such inferences. So as a lawyer, I'm going to do what I do best. And I'm going to quote from some interesting judgments. And you can decide for yourself whether anything has changed. All of these judgments are all post-2013, and they all deal with the rape law. And like a good lawyer, I brought a file and I've put it all together. This is a judgment from the Supreme Court. Just have a look at the language. The aforesaid view, and it won't take you long to guess who the judge is. The aforesaid view was expressed while dealing with the imposition of sentence. We'd like to clearly state that in a case of rape or attempt to rape, the conception of compromise under no circumstances can really be thought of. These are crimes against the body of a woman, which is her own temple. These are the offenses which suffocate the breath of life and sully the reputation. And reputation, needless to emphasize, is the richest jewel one can conceive of in life. No one would allow it to be extinguished. When a human frame is defiled, the purest treasure is lost. Dignity of a woman is part of her non-perishable and immortal self, and no one should ever think of painting it in clay. There cannot be a compromise or settlement, as it would be against her honor, which matters the most. It is sacrosanct. Sometimes solace is given that the perpetrator of the crime has acceded to enter into wedlock with her, which is nothing but putting pressure. And we say with emphasis that courts are to remain absolutely away from this subterfuge, etc., etc. So we become this temple, our body becomes this temple, purest treasure, dignity of a woman is part of her non-perishable and immortal self. Now, if this wasn't bad enough, the same court gives another judgment where it talks about it should be paramount in everyone's mind. On the one hand, society as a whole cannot preach from the pulpit about social, economic, and political equality of the sexes. And on the other, some perverted members of the same society dehumanize the woman by attacking her body and ruining her chastity. It is an assault on the individuality and inherent dignity of a woman with the mindset, and she should be elegantly servile to men. Rape is a monstrous burial of her dignity in the darkness. It is a crime against the holy body of a woman and the soul of society, and such a crime is aggravated by the manner in which it has been committed. It gets worse. We have emphasized on the manner because in the present case, the victim is a young girl who possibly would be deprived of the dreams or springs of life and might be psychologically compelled to remain in the torment of winter. What, may I ask, is happening here? This is the law that we are celebrating. This is the law post-2013. This is a law which has an expanded definition where all manner of amendments were brought about so that this language would change. Actually, nothing has changed. And we continue to talk about springs of life and torments of winter as though that is how these offences must be dealt with. So really, the situation in courts is quite tragic, and it takes a very special kind of determination for a woman to prosecute offences of this kind. And so while it is important to talk about decriminalising many forms of sexual violence, but you must also recognize that a woman going to court is quite special, because it takes every ounce of strength to stand there and to be amongst, and all of these things about in-camera trials. It might all work in Delhi, but it doesn't work anywhere else in the world. In fact, there's somebody who told me who's prosecuting the Muzaffarnagar riot cases, that when she went there and she said, the past sexual history of these women cannot be made part of your questioning. The court said, who said so? So she said, these are the amendments which came in 2013. He said, really? I didn't know that. And so she said, which is the criminal manual you have, Your Honor? And he predictably had the older criminal procedure code, which did not carry any of these amendments. So this is really we can sit here, we can talk about how the law has changed. It has not really affected anybody who either practices law outside Delhi or these big metropolitan cities, or the courts themselves. There is so much attention which is given, almost obsessively so, on post-incident conduct. Why was she looking normal? And this is something I see on a daily basis, as though a woman must have a particular demeanor when she gets up and walks out, and this again permeates into judicial pronouncements. There's an interesting judgment, which I don't know why I'm calling it interesting, only for the language, which came out again in 2016, post 2013 amendments, and I'll just read out a para or two of that judgment, where the court is obsessed about conduct. This was a case about. This is a case about a married woman, I think. So she said, the court is saying, PW1's post-incident conduct and movements are also noticeably unusual. Instead of hurrying back home in a distressed, humiliated, and devastated state, she stayed back in and around the place of occurrence, Inquired about the same from persons whom she claims to have met in the late hours of night. Returned to the spot to identify the garage and even look at the broken glass bangles, discarded litter, etc. According to her, she wandered around the place and, as disclosed by her in her evidence, to collect information so as to teach the accused a lesson. Her vengeful attitude in the facts and circumstances, as disclosed by her, if true, demonstrably envisages a conduct manifested by a feeling of frustration, stoked by an intense feeling of deprivation of something expected, desired, or promised, whatever that means. Her confident movements alone past midnight in that state are also out of the ordinary. And the court went about acquitting the accused. So I don't think anything has changed. I don't think the language has changed. I don't think the understanding has changed. And it is therefore important for us to view the 2013 amendments and all the developments since then, if we are talking about the law and the context in which these judgments are passed. And these are all Supreme Court judgments that I have cited. I have a million more, but I don't have the time. So what Madhu really says in her last chapter on reflections is absolutely correct. Virginity, institution of marriage, chastity and marriage, Shoni will talk about consent. Rape is a tool of power and oppression of social groups. All of this is relevant. And really, if some of you could be part of in-camera proceedings, I don't know how, you will see that courts are probably the last places you should come to for purposes of addressing issues of sexual violence. Thanks.